Supreme Court of India. Arvind Kejriwal vs. Central Bureau of Investigation. Decided on September 13, 2024. 2024 SCC Online SC 2550. Facts of the case. The appellant is Chief Minister of the Delhi. CBI registered an FIR under Sections 120B read with Section 477A of and Section 7 of the Prevention of Corruption Act, 1988. The FIR alleged irregularities, falsification, undue advantage, and a conspiracy among the persons holding positions of responsibility within the GNCTD, in framing and implementing the excise policy for the year 2021 to 2022. However, the appellant's name did not figure in the FIR. CBI moved an application on June 24, 2024 before the Special Judge, PC Act, under Section 41A of the CRPC, seeking to interrogate the appellant, which was thereupon allowed. Having completed interrogation and examination, the CBI filed an application on June 25, 2024 seeking permission to arrest. The trial court allowed the CBI's application. He was arrested in the instant CBI case. Appellants challenged legality of his arrest and prayed for regular bail. The High Court had denied the same. Findings of the court. In the case in hand, the trial court's approval of the CBI's application to interrogate the appellant should be viewed as satisfying the essential requirements of Section 41A, as the issuance of a formal notice through the jail authorities would have had an adverse impact on the rights of the appellant. Thus, it is our considered view that the CBI complied with the procedure encompassed within the framework of Section 41A of the CRPC, whether Section 41A(3) was violated, thereby rendering the arrest per se illegal. First, it is trite law that there is no insurmountable hurdle in the conversion of judicial custody into police custody by an order of a magistrate. Thus, there is no impediment in terms of arresting a person already in custody for the purposes of investigation, whether for the same offense or for an altogether different offense. The appellant's arrest by the CBI was thus entirely permissible, in light of the trial court's order dated 25 June 2024. Second, Section 41A(3) allows for arrest, provided the reasons are recorded justifying the necessity of such a step, and the police officer is satisfied that the individual should be arrested. Third, Section 41A(1), when read with Section 41A(3), CRPC, does not impose an absolute prohibition on the arrest of an individual against whom there exists reasonable suspicion of having committed a cognizable offense punishable with imprisonment up to 7 years. Section 41(1)(b)(2) of the CRPC clearly stipulates that an arrest under this provision can be made based on a complaint or credible information that an individual has committed a cognizable offense punishable with imprisonment up to 7 years, with or without a fine. However, such an arrest must be conducted subject to the satisfaction of specific conditions outlined in subsections A to E. Still further, Section 41(1) opens with the expression that any police officer may arrest without an order from a magistrate or without a warrant. It necessarily means that where a magistrate has issued an order, the police officer stands absolved from his statutory obligation of forming an opinion. Consequently, it becomes apparent that the variables and conditions ensconced in Section 41(1)(b)(2) of the CRPC would cease to apply in the present context. Given the order granted by the trial court prior, we are thus of the view that the appellant's arrest does not suffer with any procedural infirmity. Consequently, the plea regarding non-compliance of these provisions merits rejection, in our considered view, although the procedure for the appellant's arrest meets the requisite criteria for legality and compliance. Continued incarceration for an extended period pending trial would infringe upon established legal principles and the appellant's right to liberty, traceable to Article 21 of our Constitution. The appellant has been granted interim bail by this court in the ED matter on May 10, 2024 and July 12, 2024. Arising from the same set of facts. Additionally, several co-accused in both the CBI and ED matters have also been granted bail by the trial court, the High Court, and this court in separate proceedings. So far as the apprehension of the appellant influencing the outcome of the trial is concerned, it seems that all evidence and material relevant to the CBI's disposition is already in their possession, negating the likelihood of tampering by the appellant. Similarly, given the appellant's position and his roots in the society, there seems to be no valid reason to entertain the apprehension of his fleeing the country. In any case, in order to assuage the apprehensions of the CBI, we may impose stricter bail conditions. As regard to appellant indulging in influencing witnesses, it needs no emphasis that in the event of any such instance, it will amount to misuse of the concession of bail and necessary consequences will follow. Therefore, in the light of these extenuating circumstances and considering the foregoing analysis, it could be resolved that the appellant satisfies the requisite triple conditions for the grant of bail. We order accordingly, the appellant is directed to be released on bail in connection with FIR. The appellant shall not make any public comments on the merits of the CBI case, remain present before the trial court on each and every date of hearing unless granted exemption, and fully cooperate with the trial court for expeditious conclusion of the trial proceedings.